6:12 a.m. Eastern Standard Time. While most of the East Coast was still brewing coffee, federal vehicles were already idling outside the gates of Mar-a-Lago. At the same moment, 7:34 a.m. in New York, agents entered the lobby of Trump Tower. 40 minutes later, they arrived at Bedminster. This was not a raid for documents. This wasn't a search warrant for boxes. This was something far more permanent. US Marshals were there to change the locks. By noon, the seizure orders were executed. But the earthquake that triggered this tsunami didn't start on Friday. It started exactly 48 hours earlier, inside the most guarded room in Washington, D.C., where a witness sat alone in front of 9 Supreme Court justices. That witness was Melania Trump. And she wasn't there to remain silent. I am Maximiliano Allende. Welcome back to the channel. In a media landscape obsessed with political tribalism, we don't pick sides here. We pick up the documents. We ignore the pundits screaming on cable news, and we analyze the filings they're too lazy to read. Because right now, history isn't being made on Twitter. It's being made in the court dockets. And what dropped on the federal docket late Thursday night is, without exaggeration, the most significant asset forfeiture order in modern American history. We are talking about $1.2 billion in frozen assets, 17 prime properties across 4 states, 347 bank accounts across 6 different international jurisdictions, all of it frozen. And it happened because of what the former First Lady said under oath. Let's be very clear about the gravity of this situation. First Ladies do not testify before the Supreme Court. It simply does not happen. Yet, last Saturday, Melania Trump did not testify in a closed-door deposition. She didn't submit a written affidavit through her lawyers. She sat in the chamber, live, under oath. According to the transcripts released, which span 214 pages, she entered the building through a private tunnel at 7:14 a.m. and didn't leave until the sun went down. For nearly 12 hours, the typically private, reserved figure we know spoke. The media is telling you that she testified, but nobody is showing you what she actually gave them. I've spent the last 24 hours combing through the exhibits attached to her testimony. This isn't just about answering questions. The filings show she brought documentation, internal communications, financial records spanning 8 years, ledgers that contradict the public narrative we've been fed for months. The result? The Supreme Court, an institution known for moving at a glacial pace, issued an emergency order within 4 hours of her leaving the chair. 4 hours. That kind of speed tells us one thing. The justices saw something that scared them. They saw evidence of asset flight so severe, so undeniable, that they bypassed the appellate courts entirely and ordered immediate federal seizure. But here is the million-dollar question, or rather, the billion-dollar question. Why? Why would Melania Trump, a woman who has stood by her husband through 2 impeachments and countless investigations, suddenly hand over the keys to the kingdom? Was it betrayal? Was it survival? Or was it something much more complex? To understand the answer, we have to stop looking at the headlines and start looking at the wire transfers, specifically the ones on page 47. Because what happened between November and January wasn't just business, it was a violation of a direct court order. And Melania brought the receipts.
If you want to understand why US Marshals moved with such speed on Friday morning, you have to ignore the politics and look at the calendar. I've gone through this filing 3 times. The pattern is undeniable. and it is devastating. Here is the timeline that matters. November 14, 2025. The federal court issues a preliminary injunction. It orders all assets frozen pending trial. That means not a single dime moves without judicial approval. It's a standard procedure in high-stakes federal indictments. Now, look at page 47. According to the evidence Melania Trump provided, starting on November 19th, just 5 days after the freeze order, the money started to move. We're not talking about paying the electric bill at Mar-a-Lago. We are talking about 17 separate wire transfers originating from accounts held jointly by the former president and First Lady. The total? $847 million. Where did nearly $1 billion go in the span of 2 weeks? It didn't go to legal defense funds. It didn't go to campaign accounts. The documents list the receiving entities: Cyprus, Switzerland, the Cayman Islands. These are jurisdictions historically known for banking secrecy. But here is what the media is missing, and what we found on page 112. Melania didn't just testify that this happened. She brought the bank confirmations. She had the timestamps. These transfers were executed after the legal freeze was in place. That is the definition of contempt. But it gets worse. Scroll down to the bottom of page 112. Look at the entry for December. While the court was debating jurisdiction, another $340 million was routed through a newly formed limited liability company based in Nevada. This entity had no employees, no office, and no business history. It existed for exactly 48 hours, just long enough to receive the funds and forward them to a private equity firm in Zurich. Put those two numbers together. We're looking at over $1.1 billion moving out of the United States while the court believed the assets were secure. This brings us to the most uncomfortable realization of this entire saga. For months, prosecutors were chasing shadows. They knew the money was moving, but they couldn't prove who authorized it or where it landed. They were blocked by layers of corporate anonymity. Until Wednesday. Because Melania Trump was the co-signatory. She was the silent partner on 14 of those offshore accounts. The filing notes in dry legal language that the witness provided documentary evidence contradicting previous assertions by defense counsel that no such transfers took place. Translation: the lawyers told the court the money was safe. Melania showed the court the receipts proving it was gone. So we have the what? $1.2 billion moved illegally. We have the when, immediately after the freeze order. We have the where, offshore tax havens. But the question that made the lead defense attorney physically ill in the courtroom wasn't about the money. It was about the signature. If Melania Trump knew about these transfers, if she signed for them, why is she testifying against them now? Is she confessing to a crime, or is she revealing something much darker about how those signatures were obtained? That answer lies in Exhibit K. And trust me, you are not ready for what she said about that document.
If you only remember one thing from this entire breakdown, let it be this: page 189. Buried deep in the evidentiary filings is a document simply labeled Exhibit K. According to court reporters present in the room, when Melania Trump reached for this specific folder, her lead counsel, a man who has argued before this court for 3 decades, stood up to object. He tried to claim privilege. He tried to stop the handoff. The Chief Justice overruled him, and Melania handed it over. Why were they so terrified of Exhibit K? Because it wasn't just a bank statement. It was a transfer authorization form dated November 22nd. That is 5 days after the federal freeze order was signed. And at the bottom of the page in clear ink was the signature of the former First Lady. This is where the narrative shifts. Up until this point, the government had the what. They knew the money moved. But Exhibit K gave them the who. Justice Ketanji Brown Jackson asked the question that was on everyone's mind. Mrs. Trump, Did you understand that by signing this document, you were authorizing the movement of funds in violation of a federal court order? The room went silent. This was the moment she could have pleaded the Fifth Amendment. She could have invoked spousal privilege. She could have said, "I refuse to answer on the grounds that it may incriminate me." She didn't. Instead, she leaned into the microphone. I'm quoting directly from the transcript here. "I was told these were routine business matters. I signed where indicated. I did not know the funds were subject to a judicial order. I was told by counsel that the freeze did not apply to these specific accounts." Let's pause and analyze that statement. It sounds simple, almost naive, but legally, it is a nuclear weapon. By saying, "I was told by counsel," Melania Trump didn't just defend herself, she effectively pointed the finger at her husband's legal team. She claimed reliance on counsel. In plain English, I didn't commit a crime, my lawyers tricked me into committing one. She testified that in early January she discovered discrepancies. She realized the money hadn't just been moved for safekeeping, as she was allegedly told, it had been hidden. She then consulted with independent counsel, lawyers not paid for by the family trust, and they advised her of her own criminal exposure. Faced with the choice between prison for obstruction or testimony for immunity, she chose the testimony. The reaction inside the Supreme Court was immediate and unprecedented. Justice Alito requested a recess. Chief Justice Roberts called the attorneys to a sidebar. For 47 minutes, the proceedings stopped. The justices disappeared into their conference room. When they returned, the mood had shifted entirely. The questions stopped being about assets and started being about intent. They weren't just looking for money anymore. They were looking for the architects of the transfer. Exhibit K proved the signature was real, but Melania's testimony argued that her intent was manufactured by someone else. Now, I know what some of you are thinking. Is it possible that a woman who has navigated the highest levels of business and politics for 20 years didn't know what she was signing? Critics argue this is a convenient performance to save her own skin. Supporters say she is a victim of a legal team that used her as a shield. But the court didn't have to decide if she was naive. They only had to decide if her evidence was credible. And the filing notes, the witness demonstrated a consistent pattern of providing information against apparent personal and familial interest. Translation, she gave them more than they asked for, and that made them believe her. But while the justices were reviewing Exhibit K inside the chamber, something else was happening outside, something that wouldn't hit the news cycle until Friday morning. Because while Melania was talking, the FBI was moving.
While the mainstream media was busy speculating about what Melania wore to court, something much more important was happening on the federal docket. At 11:47 p.m. on Thursday night, less than 5 hours after the Supreme Court adjourned, a sealed indictment was filed in the District of Columbia, case number 24/1847. It wasn't for the former president. It wasn't for the former First Lady. It was for the architects. Fast forward to Friday morning, 5:15 a.m., Teterboro Airport in New Jersey. This is the preferred exit point for private aviation in the tri-state area. According to sources within the Department of Justice, 2 individuals attempted to board a private Gulfstream bound for a non-extradition country. Their flight plan had been filed just 3 hours earlier, but when they presented their passports at customs, the system flashed red. Who were they? They were 2 of the 3 senior attorneys who had advised on the asset transfers. The same attorneys Melania Trump had just testified told her the transfers were routine. They didn't make the flight. Instead, they were taken into federal custody right there on the tarmac. The third attorney? He didn't run. This is the lead counsel who sat in the Supreme Court chamber on Wednesday, the man who reportedly looked physically ill by the lunch break. He knew what was coming. He surrendered voluntarily to the FBI field office in Washington, D.C. on Friday evening. 3 lawyers, all facing charges of conspiracy to obstruct justice and making false statements to a federal tribunal. Now, you might be asking, wait, isn't advice from a lawyer protected? Isn't there attorney-client privilege? Yes, usually, but there is one major exception that every law student learns in their first year: the crime-fraud exception. Privilege disappears the moment a lawyer helps a client commit a crime. By testifying that she was misled into signing illegal transfers, Melania Trump didn't just defend herself. She pierced the corporate veil. She effectively waived privilege on those communications. She gave the Department of Justice the map, the key, and the combination to the safe. Former federal prosecutors I've spoken with call this building the ladder. You don't start at the top, you start with the fixers. You arrest the lawyers who moved the money. You show them the evidence, the transcripts, the bank records, the testimony from the First Lady, and you give them a choice. Option A, go to prison for 20 years for obstruction. Option B, cooperate. If these 3 attorneys flip, and facing federal charges, they likely will, the exposure goes significantly higher. They are the ones who know who gave the original order to move the $1 billion. So where does this leave us? Melania has testified. The money is frozen. The lawyers are in handcuffs. But for the rest of the world, the consequences are just starting to hit. We are talking about market volatility, political chaos, and a family divided in a way we have never seen in American history. And if you think this is just a rich people problem, you need to see what happened to the markets on Friday afternoon.
Now, we have to pause. We have to be fair. Because if you listen to the other side of this aisle, what happened on Saturday wasn't justice. It was the weaponization of the American family. The defense argues, and they make a compelling point, that Melania Trump was subpoenaed. She didn't walk in there because she wanted to. She walked in because the government held a gun to her head, legally. Supporters are calling this coerced testimony. They argue that by pressuring a wife to testify against her husband's interests, the special counsel has crossed a line that has stood for centuries. Spousal privilege exists to protect the sanctity of marriage. Senator Mike Lee called it the criminalization of marriage. And honestly, that is not nothing. Whatever you think of the politics, the precedent of forcing a first lady to choose between perjury and her husband is a terrifying expansion of federal power. Even Jonathan Turley, a constitutional scholar who has often defended the former president, admits that the method used to get this testimony will be debated in law schools for 50 years. But here is where the narrative of coercion hits a brick wall. On Friday evening, the former president's team released a scorching statement. They claimed Melania was threatened and spoke under duress. But less than 12 hours later, on Saturday morning, Melania's own independent counsel released a counterstatement. Quote, "Mrs. Trump testified truthfully and voluntarily. She remains committed to transparency." Read that again. Her lawyer publicly contradicted her husband's lawyer. This isn't just a legal disagreement. This is a public divorce of strategy. It confirms that inside the family, the alliances have shattered. The united front is gone. While the lawyers fight, real people are getting hurt. I'm not talking about the billionaires. I'm talking about the 800 employees who work at the properties the Marshals just seized. Mar-a-Lago employs over 500 people. Bedminster employs another 300. Groundskeepers, security guards, kitchen staff, housekeeping. These are people with mortgages and families. When the US Marshals seized those properties on Friday, those payroll accounts were frozen. We have reports that staff at Bedminster were told on Friday afternoon to go home and wait for instructions. They don't know if they have jobs on Monday. In our rush to celebrate or condemn the big target, we often forget the collateral damage.
These are real livelihoods hanging in the balance of a court order they had nothing to do with. And then there's your wallet. You might think, I don't have $1.2 billion, so this doesn't affect me. Wrong. When the news broke on Friday afternoon that a former president's assets were being seized, the markets reacted with fear. Uncertainty is the enemy of investment. Futures dropped 2.3% before recovering. Why? Because investors are asking, if the government can seize assets this fast, whose assets are safe? We saw a flight to safety. Gold and bonds spiked. If this legal battle drags on, if it creates instability in the transition of power or the upcoming election cycle, that volatility hits your 401k, it hits your gas prices, it hits the stability of the dollar. Finally, there is the elephant in the room, the question nobody wants to answer. Did Melania Trump cut a deal? The filing is silent on immunity, but let's use common sense. She admitted to signing illegal transfer documents. In a vacuum, that is a crime. Yet she walked out of that courthouse free, while her lawyers were arrested at the airport. You don't need a law degree to do the math. Someone offered her a lifeline, and she took it. This leaves us with a fractured reality. To one side, she is a traitor who saved herself. To the other, she is a whistleblower who finally did the right thing. But perhaps she is simply a woman who looked at the chessboard, saw checkmate, and decided she wasn't going to be the pawn that got sacrificed.
So, where does this leave us? The testimony is done, the assets are frozen, the lawyers are in custody. But the war is far from over. In fact, next week is when the real battle begins. If you are tracking this case, and you should be, because it will define the next decade of American jurisprudence, here are the dates you need to circle in red. Monday, February 9th, 10 a.m., Federal District Court in D.C. This is the arraignment for the 3 attorneys arrested this weekend. This is where we learn exactly what they are charged with. Will they plead guilty? Will they cut a deal? Or will they stand tall and risk decades in prison? I'll be covering that live. Tuesday, February 10th, the House Oversight Committee convenes an emergency hearing. Expect political theater, expect shouting, but don't get distracted by the noise. Watch the subpoenas they issue. Thursday, February 12th, this is Judgment Day. The Supreme Court reconvenes to decide if the asset seizure becomes permanent. If they uphold the order, the Trump family loses control of $1.2 billion forever. If they modify it, the assets might be released. Everything hinges on Thursday. But before we go, I want to leave you with something more than just dates and dockets. I want to talk about the lesson buried in these 214 pages of testimony. We spend so much time looking at the politics of this, left versus right, red versus blue, that we miss the human tragedy at the center. What we witnessed this week wasn't just a legal maneuver, it was the collapse of absolute loyalty. For years, we were told that this circle was impenetrable, that the loyalty was absolute, that the family was a fortress. But Exhibit K taught us a hard truth about human nature. When the walls close in and the choices are prison or survival, survival wins. Melania Trump didn't testify because she hates her husband. She didn't testify because she loves the government. She testified because, in the end, when the music stops, everyone, even a first lady, has to look out for themselves. The lesson here isn't about politics, it's about power. Power is fragile. It relies on the silence of others. And as we saw this week, silence is a luxury that vanished the moment the handcuffs came out at Teterboro Airport. There's an old saying in contract law, read the fine print, because the large print giveth, but the small print taketh away. For decades, people have signed the large print without looking. This week, Melania Trump finally read the fine print, and the result shook the world. So ask yourself, If the people at the very top, with all their billions, all their lawyers, and all their power, can be dismantled by a single signature on a transfer form, what does that say about the illusion of invincibility? Maybe there is no such thing as too big to fail. Maybe there is only too slow to read. This story is moving faster than anything I have ever covered. The arraignment is Monday. The Supreme Court is Thursday. I will be here for both. I don't deal in rumors. I don't deal in spin. I deal in documents. If you found value in this breakdown, if you learned something the mainstream media didn't tell you, do me a favor. Hit that subscribe button, not just to support the channel, but to make sure you get the notification when the arraignment documents drop on Monday morning. Leave a comment below. Do you think the attorneys will flip? Yes or no? I want to hear your prediction. I'm Maximiliano Allende. Stay skeptical, stay informed, and always read the fine print.